I think we have sufficient time, but I will take your questions at the end. On your screen, you should see the PowerPoint as the center of your screen, and that should take up most of your screen, and then I should be down in a very small box on the bottom right-hand side of the screen. On the left side of the menu, you should see something that looks like a question mark or like a conversation box. That's the question and answer icon. If you have any questions, just type it in there. Again, we'll try and get to all of those at the end of the webinar. For your CMCA credits, those are automatically generated once the webinar host sends us a list of all of the people who have signed up and logged on. We get that list within about 48 hours of the webinar, and then we will send out your CMCA credits. Those credits aren't transferable. If you have any questions or problems, you can email Summer Sims at ssims@altitude.law, or you can call 303-991-2076 if you're having any problems with connectivity or questions about your CMCA certificates. All right, so let's jump into this. This is about negligence. Obviously, one of the things that we always have to have is a disclaimer, because you wouldn't think I was really an attorney if I didn't give you a disclaimer. I can't give you legal advice because so often in situations with HOAs, it all depends on what your governing documents say, and that's going to be different for every one of you. So this is meant to provide you some direction, where to look, what to think about, and help you when you are in that circumstance so that you know when you need to call the lawyers. As always, we have additional resources on our internet. Please log on. There are tons of articles about negligence, about water leaks, all those fun things that you guys, managers, board members, have to deal with. And also, you know, obviously, the legislative session is soon to be upon us. So if you want to hear our thoughts of what's coming up and what you're going to see this year, please sign up for our blog and our newsletter. All right. So, you know, what are we thinking about? When we start talking about negligence, why do we care? What's the issue? The issue is that many times when there is damage to the community, the question is not as simple as who owns it. It's not as simple as who insures it. Many times the answer on what happens and where we're going to go is whose fault is it? Meaning who's negligent? You know, when we think about something, you know, a person falls down the stairs at an association. First thing, you know, the association says is, oh my God, is that coming out of my pocketbook? You know, where are we going to find the funds for that? Is it insurance? Are they going to pay for it? Who's going to pay for it? Are we going to get sued? Obviously, if you're thinking, you know, something bad has happened, something's concerning, to protect the association, there are some immediate steps that you should always think of as a manager, which is go out there and take photos immediately. Right? Go take photos showing that the step's not damaged. Go take photos showing there's no ice, that there's snow melt right there. It's all nice and clear. So they fell. We're really sorry they fell. We're going to try and help them, but it doesn't look like it's our fault. Don't wait 2 months later till you get that lawsuit and that accusation and it says, well, she slipped on ice. And you're like, well, I don't remember any ice. If you find out somebody was hurt that day, go get photos of it that day so that you have it and you can have it for later. So when we start looking at, you know, what are we thinking about? You know, do we have to, who's responsible? You know, who has to pay this bill? What's going to happen? We have to start with obligations, right? It's not just simply, do you own it, right? Maybe you don't own it, but maybe you had a responsibility to maintain it. In many cities, the cities may own the sidewalks, but they create a statute that says whoever owns the land that butts up next to the sidewalk has a duty to clear the snow and ice. Well, what if the land that butts up next to the sidewalk is the HOAs? And if you don't know that that obligation exists, you may have just found a liability of the community, because here's this city statute saying you have a duty to be shoveling that sidewalk and you haven't been doing it. So first things first, when something like this happens, we have to find out whose duty is it to maintain that area, right? Ownership is important. Don't get me wrong. We need to know who owns it, but we also need to look to different areas to see if, in fact, there is a duty to maintain it. That might be a statutory duty. It might be a duty from the covenants. It might be a subdivision agreement. You might have a sidewalk that goes between two communities, and 20 years ago those two communities created a subdivision agreement between the two communities saying who's going to shovel that sidewalk, who's going to repair that sidewalk, who's going to maintain that sidewalk. So step one is who has to maintain it. Obviously we're always looking at our duties, again, whether they're contractual, statutory, in the covenants, because that's where we're going to start looking. Well, when are we liable for something, right? That's the big question. Not just do we have to maintain it, but when are we liable? Well, once you find out if you have any duty or responsibility, then did you breach that duty? Did the breach cause the damage? And are there actual damages, right? Sometimes we hear people make claims of defamation, and why? Because they called somebody a name, and maybe somebody did call somebody a name, but you have to connect that there's damages because of what happened, right? Again, sometimes you hear things like, I'm going to sue you. You're responsible. Like your neighbor's watching you hang Christmas lights and drives into a tree. Well, your hanging the Christmas lights didn't cause him to drive into the tree, and he might have damages, but he can't connect anything to you doing something, right? So you have to connect the dots. There has to be a duty, a breach. The breach causes the damages, and there have to be actual damages. So when we're talking theories of liability, negligence is the primary one, and that's the one we're going to focus on primarily, but we'll briefly touch upon some of these others because there's other theories of liability. One of the ones that I think is most probably misunderstood is strict liability, and we'll touch on that one a little. Nuisance is something that not only is in all of your covenants, it's actually a common laws theory, a complaint. Breach of contracts, our communities all have tons and tons of contracts, and breach of contract is often one of the theories of liability. Trespass, again, that's both common law. There's also the crime of trespass in our criminal codes, and then there's discrimination. So there's many theories of liability, and negligence is just one of those many theories. So what are we thinking about negligence? Negligence means that property must be repaired and maintained in accordance with what a reasonable person would do under the circumstance. And when we talk about reasonable person, this is a hypothetical individual who approaches a situation with the appropriate amount of caution and sensibilities and takes action as the common man would do so. So again, it's one of those things that often goes to a jury, and the issue is, did you do what is reasonable under the circumstances? And so that often becomes a question, and oftentimes you end up arguing with the other side saying it was reasonable. No, it wasn't. Yes, it was. And you have to understand that a lot of cases get settled because it's not black and white. It's what a reasonable person would do. When we're looking for the court case itself, again, it goes back to those general kind of terms I covered a minute ago. Start with that duty. Did the person owe a legal duty to the association, or did the association owe a legal duty to someone? Was there a breach in that legal duty? And was the person's actions or inactions what actually caused the injury? Were there damages suffered by the HOA or suffered by a person because of the action or inaction by a person or the association? Strict liability is something that often comes up, and probably the most common thing that I see with this is water leaks. if I'm in the downstairs and there is an upstairs unit that all of a sudden has a water leak down on my head, as the downstairs unit, I want somebody besides me, of course, to pay for the damages for that water leak. But realistically, that's not strict liability. Just because it leaked doesn't mean the upstairs is responsible. Strict liability, the most common strict liability that we're all aware of is speeding, right? When you go speed down the road and you're driving and racing to get somewhere, cop doesn't care if you meant to speed, doesn't care if you didn't mean to speed. It's strict liability. If you were speeding, you're liable. Okay, that is a strict liability crime. There's no intent needed. And that's really kind of, it's rare that you have strict liability. It's generally the times you can connect strict liability is when there's some statutory obligation. Sometimes you'll see strict liability. But that's, one of those things that we often come across when we're looking at that. And downstairs neighbors always presume it's strict liability. Well, it leaked from upstairs, so they have to fix it, right? And the answer is no. So when you're that manager and you get that call about the leak, it's not automatically whoever's upstairs' fault. And if upstairs happens to be the HOA roof, it doesn't automatically mean you're responsible. You have to look through the documents to figure out if you're negligent before you have to pay for that damage. And also there's always issues of insurance and who has to insure it that come into play when we're talking about water leak. One of the things that, gets really confusing is you hear the terms, probably you've read them 100 times, but you don't think about it. But we all pay for insurance, and many times the best answer is to turn it over to insurance and let them sort it out. In an HOA, there is a very long discussion that has to come into play when we hear about a water leak. It's not strict liability. When you have that water leak, you first have to find out who owns whatever the component is that's leaking. That's the start, right? Because what we have to figure out is that first thing of a duty. Do we have a duty, right? And I said that would be the first test. So in a water leak, first we have to figure out who owns whatever's leaking. So let's assume that what's leaking is the roof. And if the HOA owns the roof, that's step one. Now the next step is, do we have the duty to maintain it? In a condo and a townhome, probably, because that's in the declaration, but you got to look that up. And then who has a duty to insure it? Is it the same? It might be, might not be. As you work through that, then you have to figure out what's the amount of damage. Do we turn it over to insurance? And just because the roof leaked, we found out who owns it, we found out who insured it, we decided if we aren't going to turn it over to insurance based on the amount of damage, none of that automatically means you're responsible for the damage the leak caused to the interior down below. It's only if you're negligent, right? Because if you're negligent, that means it leaked last week when it rained, and we didn't call out a roofer to come fix it. We just said, yeah, we'll get to it. So if we knew it and we didn't fix it, there's a good chance that we'll be held to have breached our duty of the reasonable person, right? So we just decided the roof is ours, it's ours to fix, there's our duty, it's leaking, and we knew about it and didn't fix it. That's going to be a breach of our duty. And it's, if a reasonable person says, when the roof leaks, I need to fix it so it doesn't ruin my stuff, and we didn't do anything about it, that's probably a breach of our reasonable responsibility. So now we're negligent. So now when that downstairs person calls and says, you've ruined my stuff, are you responsible? Well, you might be, because you were negligent. Not strict liability, but negligence. So knowledge, did it happen before? Did you take no steps to fix it? Those are all very, very important. Nuisance is one of those other ones that we were talking about. A nuisance is an invasion of an individual's interest in the use and enjoyment of his property, right? In the old cases, when you start looking at nuisance in the courts, what you often find is pig farms, horse farms. The smell, living next to that smell, creates the nuisance. And then the issue is, did people move in when it was there? For those of you looking at governing docs, you'll often see notices in your documents that say things aren't a nuisance, right? Like the golf course. You've moved next to the golf course, therefore you can't claim the golf course is a nuisance when those golf balls are hitting your house. You've moved next to the airport. You can't complain that you don't like the sound of the planes flying over, right? So when we're talking the old concepts of nuisance and common law, right? We're not talking the nuisance paragraph that you have in your covenants. This is common law concept of nuisance. It's when something is so substantial that it affects the use and enjoyment of your property. Okay, and always it matters whether you move towards it or it came after you were there. And so this is often something that we often have as a nuisance. Understand it has to be a substantial invasion of an individual interest to be a nuisance under common law. Most of the nuisances that we deal with when we're talking covenants are the nuisance provisions in our covenants that are, there to stop the neighbor who won't turn down his radio. And that's really not going to, most of the time, here and there events, here and there parties are not going to fall under the old common law substantial invasion, but they will fall under the nuisance provisions of your covenants. Understand that at what point does it become that substantial invasion? And when it's every day, all day, you're going to start moving towards that substantial invasion to the point where you might be violating the common law concept of nuisance. And that is a very different lawsuit than filing a lawsuit for somebody having a one event party here and there. Breach of contract was another one of those that we were talking about, is a theory of liability. This is one where HOAs get themselves in trouble generally because the contract is not very clear. And while attorneys are annoying and frustrating and having to have a numerous page document just to get some work done may seem very frustrating to a board, when things go south, when you don't have that multiple page document, is probably the biggest problem, because we don't know what the terms are. We don't know, how do we define what the obligations were? Then we're getting into, he said it was supposed to be this scope, she said it was supposed to be that scope. Who's right? Who really knows what's going on? And trying to prove breach of contract becomes almost impossible because we can't tell what the scope was because the terms aren't clear. If you do have a good contract, it is so much easier to define, here's the contract, here's what the terms were, here's what the scope was, and here's where the violation happened. And here's why the HOA can sue the vendor, because they failed to meet the obligations that were clearly set forth in the contract. I know it's a difficult thing for an HOA to try and think about, well, when is it worthwhile to spend the money to have the lawyer look over the contract? But you need to think and be very cynical, which is, how much money can you afford to throw away? Because the contract isn't clear enough to tell you who's in the right and who's in the wrong. You may be throwing away the money because you can't enforce it if you don't have a clear contract. Obviously, the slide I thought was pretty funny, because obviously, breach of contract isn't any fun, but the data breaches that everybody seems to be having aren't any fun either. And that's another problem that we see, and that's a trespass, because when someone breaks into your network and takes information, they're trespassing. And so that just leads right into the trespass obligation, which is trespass is one of those things that we don't always think about. And we really don't think about them probably in the way the lawyers think about it. If I'm uphill on a street and water runs off my property downhill towards the neighbor, that's the normal course of the water. But if I am maybe pretty level with my neighbor and I change the grade of my property to force the water off my property onto the neighbor's property, I'm actually causing a trespass against that neighbor. And so when owners change the grade of their property and force water from their property onto a neighbor, and they've actually caused a trespass. I know we don't think about it that way very often, but in HOAs, that's how HOAs get involved with trespasses. Obviously, we also have people who trespass across our common areas, and sometimes in a car and do damage. But the more prevalent trespasses we see in HOAs are actually water. And so you always have to be careful that you can't do something to cause something bad to happen to your neighbor's property. I forget the order of my slides. I put that in there so I'd have a reason to take a break and get a drink, and I forgot I had it there. Okay, so I think the last reason that I had for the different types of liability was discrimination. And again, this pops up in HOAs all the time as well. We often have claims of discrimination, and the claim is always one of those things where they assert that the HOA has purposely discriminated against them. Most of the time, what's really happening is the homeowner is trying to make a claim for selective enforcement. It's not really technically discrimination as we think about it in the law. It's that you've enforced against him and not against his neighbor, and that's a selective enforcement type of situation, not the discrimination. Although obviously HOAs constantly have to deal with the claims of discrimination when people make requests under FHA. So it does come up in that regard too. But when you start thinking about discrimination, you always have to remember that discrimination is only against those protected classes that were in the prior slide, right? You could all have a rule that says no lawyers in our community, and I can't complain that you're discriminating against me because I'm not a protected class as a lawyer. So it has to be a protected class. All right, let's talk about some common liability issues that we see, right? So as I said, water leaks are those real common things that we have to look at and we have to be prepared for. There are a couple of articles on our website that I highly recommend that help you walk through the steps when you get that call for the water leak. You know, we're in that perfect season for you guys to get the awful calls of pipe bursts because we're in that cold, hot, cold, hot, cold, hot. And fall and spring seem to be that period of time when we see a lot of water leaks for that very reason. And when you have that water leak from the roof, you want to walk through that process that I kind of started a moment ago, which is step one, where's the water coming from? Who owns that, right? When you know where the water comes from, it's the roof. Who owns it? Who has to insure it? Who has to maintain it? You have to walk through those things. You need to know how much it's going to cost to fix it, right? Because you need to know, is it worthwhile to turn over to insurance, not turn over to insurance? Has it ever leaked before? Did we know about it? Have we done repairs to keep it up to speed? There are a lot of steps you got to walk through to figure out what we're talking about when it's a roof leak. If you have that roof leak, if you've had prior roof leaks, you should be having some light bulb just blinking away at you. Oh my gosh, there could be claims of negligence, because once those claims of negligence come up, you're not only now responsible for repairing what you are required to repair per the documents, but because you were negligent, you may have to pay to repair things that you wouldn't have been responsible for before, right? So let's assume, first thing, brand new roof, just had it done. Nothing's ever happened. We get a roof leak. We find out HOA is responsible. We're the owner. We're the responsible party. We got to go repair it. So we go repair it. But the person who's in the unit says, no, 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 you have to come fix my piano because it poured water on my piano and you're responsible to fix that piano. And your answer is going to be, no, I'm not. That piano is not mine, and I'm not responsible for your piano. I had no knowledge that the roof was going to leak, and you'll need to turn it over to your insurance, Mr. Unit Resident, unit owner, whatever the case may be, but that's not mine because I'm not negligent and I'm going to fix the roof. Okay, let's take a next situation. There was a prior roof leak. The board's looking at repairing all the roofs. We've got a contract. They're gonna start doing the roof work in a week, and it starts raining. And it rains and it damages that piano. Are you responsible? You might be. While you've acted responsibly, you knew the roof was there. You know, what steps did you take to the owners to tell them the roofer's gonna start in a week? Did you tell everybody in the community, look, roofers are going to start in a week. I know it's rainy season, so if you get a leak, let us know as soon as possible. We'll try and come help you move things so there are damages. What steps did you take as a responsible, reasonable person to make sure that person and their piano wasn't damaged? That's the kind of analysis you're going to have to go through if you've already had a leak and you get a next leak, because now negligence is part of the discussion, right? There's no absolutes, there's no automatic information. It's, did you act in a reasonable manner, right? And so that's going to take some discussions. So always be aware of that. Also, for all of your communities, when we're talking about these discussions, you know, do you turn it into your insurance? Do you not turn it over your insurance? That's going to depend on your deductible. And talk to your lawyers, whoever they are for your community, and find out for your communities, do you have the ability to shift the deductible? Does it just get applied to everybody? Does it apply to just one person? That becomes so important when we start talking sewer backups, right? If you have a sewer backup and there's been no prior problems with the sewer, right? And you have to go in there and clean, and there's been a horrible cleanup, and you have coverage and you send the insurance in there, you're still going to have a deductible. Who has to pay that deductible? Well, it might depend on when they clean out the sewer. Was it the cause of the owner who, you know, was living in that unit? But it also is going to depend on your documents, because your documents may or may not allow you to shift that deductible. And sometimes they allow you to shift that deductible only if you have a separate policy saying how the deductible is shifted, right? Don't presume you can just say to the homeowner, oh, no, 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 that's your problem. The sewer backed up. You stuff stuff down. It's all on you, okay? Don't make that presumption, because that's a very, very expensive one. And most homeowners don't carry enough sewer backup insurance. And so they're going to sue you rather than pay it. So make sure that you have looked at your documents, you've worked with your attorney. Can you shift the deductible? Is somebody else responsible? When can you say that it's the owner that was the negligent party versus not? Be aware that, you know, if you've got an upstairs unit and a downstairs unit, both of them are adding to whatever's going in that sewer. And so it's going to be pretty hard to determine which one was responsible for causing the backup, okay? And who's negligent? You know, who was pouring grease down their sink? Who wasn't? And trying to prove it, if you can't prove it, you don't get to just assign it. So be aware of those things. Be aware of the discussion of, you know, whether they're negligence or not. Looking at swimming pools, right? Those are common liability areas. Obviously, we've seen a fair number of discrimination claims If you've drafted rules that try to say adult only times, or we've seen people who complain on a religious basis if you try and assert what is proper to be worn in a pool. Be aware there's lots of things you have to keep in mind. Stay away from liability in the pool area. But when we're talking the personal injury claim, we're going to go back to that negligence discussion, because when we're talking personal injury, you have to remember you are held to that reasonable standard, right? Did you put proper signs up letting everybody know there's not going to be a lifeguard? Did you control access to limit how many people were in there? Did you fence it as required by the state and as required to, again, protect and limit access? All those things are things that you have to think about. Was the, pools are always something that are hazardous. That's just part of the nature. They are something that the law looks at as something where when you go on a pool area, that's going to be slippery. That's an acknowledgement. That's the normal course. But again, if you have to go in front of a jury and explain your position and why it's not your fault some young child got severely injured, that jury is going to be very, very sympathetic to the small child. And so it's always a risk, and there's always going to be liability. And it's never going to be limited to just the law, because you're always going to have emotion play into those things. So it's not just the liability, there's also emotion. Cameras can cause liability. Having cameras around a pool are a good thing sometimes, because it helps you define what happened, when it happened, how it happened. But at the same time, they can also cause separate liability areas, because homeowners can make claims that they relied upon the HOA monitoring those cameras at all times, and that reliance was not founded in fact. So if you're not monitoring it, but you're just recording for use later in case there's somebody came into damage, you need to make sure your signs show that, so someone can't claim that relied upon you monitoring the cameras. Snow removal. That becomes a big issue, obviously, in Colorado. That's something we all have. We all have to deal with slip and fall claims. The main thing that you always have to think about on the slip and fall claims are, where's your obligation? Where's your areas you're responsible for? I mean, that's the first thing you have to look at. Are you responsible to shovel the sidewalks? And you really need to know your area, know your community, know what sidewalks you own that land and have responsibility to maintain, know what areas may be owned by the city, and the city has shuffled over that liability and that responsibility over to you because you have land next to it. Many cities write ordinances that state, if you own the land that abuts up next to a sidewalk, you are the responsible party to shovel that sidewalk. You've got to look for that. You've got to ask your attorney to help you look for it if you don't know about it, because you don't want to have the claim made against you that you didn't shovel the sidewalk, it was your responsibility to do so, and now they slipped and fell. Be aware of that. What if you have those areas that freeze, thaw, freeze, thaw? Happens all the time in Colorado. If you know about it, you have to take reasonable steps to protect people from it. How do you take those reasonable steps? What's reasonable? One of the things that you can do is put out buckets of ice melt, right? Put out signs. You know the areas there. There's a sidewalk and there is an eave of a building, and it always drips in that one place. And then it, of course, freezes, right? So talk to your contractors. Can we do something? Can we redirect the drip? Can we find a way to put a sign up or do something to protect people from that area? You've got to take steps that are reasonable for the common person so that nobody's injured. And, if it constantly happens and causes a hazardous area, then you need to work with vendors to redirect it, to fix it, to change it. You can't ignore it. You have to do something. And so that's something that you have to work with. owners, and we're going to talk about this in a minute, it makes it different who slips and falls, right? It's not everybody's treated the same, right? And so we're going to take a look at that in a minute, and we'll go through that a little bit more. So like on water leaks, and I think I went through all of this already, who owns it, who maintains it, what caused the leak, what are the damages, what are the things that are damaged. One of the things that you have to think about is the area damaged common area that the HOA has to repair? Is it area that is damaged personal property of the owner, or is it an area the owner is responsible to repair? Again, if you're not negligent and you don't have a duty to repair the areas that the leak damaged, there's no strict liability. So roof leaks, it leaks onto an interior floor. The interior floor is the owner's responsibility to repair. HOA doesn't have to repair that floor just because their roof leaked, unless they were negligent, right? So was there a prior leak and you did nothing? Well, now you're going to have to pay for the floor too. Swimming pool, as I said, there are different rules that you need to be aware of. You need to think about, you need to work through. You need to, again, always be thinking of the reasonable person. What is reasonable and responsible? Sometimes as a manager, we get hooked into helping our boards, tighten the budget and make sure we don't spend too much money. Don't forget to step back and think about, are we spending enough to be that reasonable person that we're taking all the necessary steps that a reasonable person would take to protect people from injury. Don't always assume or presume one way or another. I know we all want to save money, but we want to make sure that we do what we need to do for injury claims. Cameras, I kind of went through this somewhat when I was looking at the main slide, but one of the other things you need to be careful with cameras is where you're pointing them. You don't want to, obviously you cannot have them in a restroom, you cannot have them in a locker room. You want to make sure they're properly signed so everybody knows that they're just up, so that you have some protection against vandalism. They're not being monitored. Dummy camera versus regular camera, you run into the same thing. You have to put up signs so that people can't make claims of reliance. And then you always have to remember, when you start recording things, who are you going to let look at the, right? Who are you going to let see the camera footage, right? How long are you going to keep it? What are you going to do with it? You want to be aware and think in advance about that, because that often comes up as a question when you have those photos after the fact. Who can see them? And that, if you want to expand on if you're going to keep them, then you need to think about making sure your records inspection policy talks about that, because you have it, how long you're going to keep it, and when you're going to get rid of it. As I said, in Colorado, slip and fall is one of our most common lawsuits that we see. So we want to make sure when we have a duty to remove that snow. And what I was kind of alluding to is it makes a difference who slipped and fell, right? In Colorado, we have what's called the Premises Liability Act. And that statute basically says there's 4 categories of claimants. There's an owner, an invitee, a licensee, and a trespasser. And so when we're looking at that, the law says that as an association, my duty to an owner is different than my duty to a trespasser, which makes sense, right? If somebody's going to break onto my property, I don't have the same duties to a trespasser than I have to an owner. And so when we're talking about, we started this, we talked about negligence, and we said, look, there's this general negligence principle that you have to repair your property in accordance with the reasonable person would do under similar circumstance. So the duty owed to an association to non-owner claimant is different than that. So to my owners, I have to make sure that I'm taking care of the property as to what a reasonable person would do, right? But when I'm talking about an invitee, this is, somebody who's a guest of the community. It might be a vendor, right, who's coming on the community. So the duty to an invitee is to exercise reasonable care against dangers I know about or I should have known, right? So if I have that slip and fall hazard, right? I have that area where the water always drips off the roof and then it freezes on the sidewalk. I know about that. Or I should know about it because it's my sidewalk that I have to maintain. I have to make sure that I take proper steps, reasonable care to protect any of my owners or invitees against that drip. Okay, what about the licensee? Well, for a licensee, it's only about dangers I create and I know. And so then the issue is, did I create the drip? Well, it's my property, so yes, I did. And then for a trespasser, it's only willful or deliberate action caused by the association. So again, there are a series of questions that you have to look at. You have to kind of rely upon when you're talking about in Colorado about that slip and fall. And it does depend on who slipped, who fell, and why. And it does change, okay? And so you have to look at that and accept that that's going to change. How does deferred maintenance come into it? Well, that comes into play when you have those steps, maybe that are HOA maintained, and you've put off replacing them, and now they're shaky, and they're in disrepair, and somebody fell on them, right? Well, if your deferred maintenance caused somebody to fall, now you're going to be responsible for their injuries. So you have to be aware of, back when I was talking, you're trying to pinch pennies, you're trying to protect your community, and you're trying to budget. Don't budget so tightly that you don't maintain things you have a duty to maintain, and now somebody's going to get hurt. What about damages caused by vendors? Sometimes that's going to fall back on the HOA. Sometimes it's going to fall on the vendor. And that is one of those things that kind of comes back to the contract. Remember, we want to talk, you often have vendors who present you an estimate and the HOA signs it and says, go to work. Who's insuring their work? Who's ensuring that if they do damage, it's going to be repaired? Who's taking care to make sure that everything they did doesn't damage your property or someone else's property? You need to look at their negligence questions, right? And are they, covered? And so, are there indemnifications? Are they indemnifying you? Are you indemnifying them? Those are all contract issues, but there's also negligence issues merged in with those, depending on what happened. And so you have to be willing to dig down in and start looking at everybody's actions. But again, that comes back to that contract to begin with. Again, your best practices to protect your community is know your governing documents and know your duties. I mean, those are going to be the most important. Limitations, your liability clause, there's only so much that the courts will let you avoid and disclaim. And if you aren't being reasonable and you are negligent, all the disclaimers in the world might just be ignored by a court, right? Waivers are helpful because what waivers do is they put people on notice, right? And remember that if we tell people, be careful of this, be careful of that, if you're going to use the pool, you're using it at your own risk because we don't put a lifeguard there, you're notifying them, you're putting them on notice that they are in charge of their own safety, and that helps you, right? If you follow your documents, keeping a record to show that you followed them, it helps you down the road. Okay. So again, if you hear of somebody who slipped, rush outside and take pictures to show that the steps are maintained, they're not damaged, there's no ice, shows that you followed all of the obligations that you have. Looking to make sure that contracts are reviewed, make sure your rules are reviewed before adopted. Obviously, one of your biggest and strongest defenses in any claim at any point in time is that you follow the business judgment rule and that you made your decisions in good faith, because that always is going to help you in a lawsuit. It doesn't stop negligence, but it does help a lot of other claims against you. Contracts, don't sign estimates. Really, it just bites you. because you can't go back. If they do a bad job, they're going to claim that they did what they had written on the estimate. The estimate's going to be strong enough to tell you anything. If they damage your property, you're not even going to have a requirement they be insured. You're not going to have any proof of anything. It's just a bad plan. Review, make sure there is a contract, make sure it says what you guys are agreeing to, and then make sure that it shows what the obligations are on both sides, and that the contract requires all of the vendors to have insurance. Make sure you guys have insurance. All of these things are just absolute. You always have to have insurance, and those contracts need to make sure your vendors always have insurance. Know when it's yours. Know when the obligations are yours, right? Make sure that you know when it's your duty to act or when it's somebody else's. If it's somebody else's, have them act, not you. Okay. Let me go through questions because I have a whole bunch of them here. Go back up. So, address light infringing on a neighboring property. Okay, I don't think you're ever going to have light bleeding over, get to a level of the common law claim of nuisance. Not unless it's a ballpark. You know, if you got Coors Field lighting there, you might get to nuisance on the level of common law nuisance. Now, if you're just talking to your documents prohibit light glare, that's going to be a case-by-case analysis. It's going to depend on your governing documents. If your governing documents aren't clear, then I would recommend adopting rules to clarify what is too much light or not enough light. And you might be able to look and go online to kind of dark sky initiatives, and that might help you find ways to define it so that it's a clear definition so you can tell whether it's too much light or not enough light or whatever the case may be. But that's going to depend on your governing documents, and that's going to depend on your rules to determine if in fact what the owner's doing is a violation of that or not. I think I addressed the thaw and freeze of ice. Again, it's what would a reasonable person do, and if you have that area that always freezes and thaws, what can you do to change it? What can you do to protect people? Can you put proper signs up? Can you redirect the water so if it does freeze, it goes off the sidewalk, it doesn't freeze back onto the sidewalk? You have to evaluate it. Tell your board members, what would you do if this was the sidewalk their mother walked down every day? How would you reasonably protect her? Make them think in mind of they have a duty to the safety. How would they reasonably protect people that they care about? And, work for an answer. One neighbor complains of another's barking dog. Is it a nuisance for the neighbor? Is the HOA responsible? It's going to depend on your governing documents. Again, that's not this type of nuisance that I'm talking about in common law. Common law did not care about one neighbor's dog barking. That would not be a common law nuisance. Now, is it a nuisance under your governing documents? It might be. The problem you're going to find right now is under HB 1137, if you're a Kiowa community, unless that dog barks nonstop continuously for 60 days, you can't turn it over to a lawyer. If it doesn't bark nonstop for 30 days, you can't fine the dog. Generally, with dog barking, people call the HOA because the HOA they don't have to do anything, right? They can say, hey, HOA, you deal with it, I'm not going to. Whereas if they call the code enforcement is going to make them sign. So you get to know who's complaining. And a lot of times, some code enforcement requires two neighbors to sign, right? And so you have to make sure that it's not a neighbor on neighbor who just don't like one another and they're making up complaints. Right now with 1137, your hands are pretty much tied. I would, if I were you, try and turn it over and push them and say 1137 has tied your hands. It's better if they call animal control. Regarding negligence for something like a roof leak that damages someone's floor. should the HOA just default to not replacing the floor unless the homeowner files a lawsuit? Would that be a good or bad idea to just submit the repair to insurance and see if they'll cover it? So the choice to turn it over to insurance is one that is a board choice, and I don't think you can ever predetermine always do A or always do B. And here's why. Insurance companies keep a claims record, and that claims record affects the cost of your policy next year, right? So if you're always filing claims, you're going to have a long claims record, and now your insurance are going to be higher, right? Your costs. And all of us know that's one of our huge costs for our communities anyway. And so we really don't want to increase our costs with just always turn over to insurance. So how do you evaluate it? So when you're talking the roof leak, step one, is that floor the HOA's floor? Most of the times, the floor, the interior floor, is the carpet, or might be hardwood, might be tile. That's something is the owners to change out and decorate, right? And so most of the time when it's the homeowners to change out and decorate the carpet, the whatever, it's not the HOA's responsibility to replace the floor. It's only if the HOA is negligent. So if the HOA is negligent, we knew the roof was leaking, we didn't fix the roof, and now it damaged their floor, should you pay for it? Well, if the cost of the floor is $2,000 and your insurance deductible is $5,000, if they sue you, you have to pay the first $5,000 in insurance, dollars to dollars. Obviously, it was cheaper just to pay for the floor, which means every time that you have the circumstance where there's a claim, somebody says you have to pay this much for me, your board has to analyze it. One, are we negligent? If there's no risk of negligence, right? Never had a roof leak before, nobody's ever told us the roof's leaked, and all of a sudden it leaked, it's not your responsibility. There is no strict liability to just have to replace the floor. So if the floor is not the HOA's, the HOA wasn't negligent, you don't have to replace the floor. Tell them to replace it. Explain to them. That's why they should have their own insurance. It's theirs to repair and maintain, so they get to maintain it. So they can repair it, they can insure it, or they can turn it to their insurance company. I have many ground contracts that specify 12 hours to begin snow removal. If someone slips within that 12-hour time frame, does that affect the HOA responsibility or liability? Here you go, guys. Lawyer's favorite answer. It depends. It really does. So if the snow starts falling at, 3 o'clock, and everyone is going to get out there at 3:30 to pick up their kids. 5 o'clock, they're going to be on the sidewalk, walking towards the mailbox to get their mail when they get home from work, walking down the sidewalk after they park the car to head into their, house. And that sidewalk is slippery because you haven't shoveled it yet. Is that reasonable? Well, if it just started snowing, it takes time to get the vendors out and everybody, there's a lot of different places. And so, there's some acceptance to if it just starts, okay, we kind of all know, it's going to take a while before it starts snowing, and they're not going to start shoveling until it starts build up. So it's going to take some time, right? Well, okay, maybe. So if your 12-hour window is always met, that means that, if it starts snowing at 3 o'clock in the afternoon, then by 8 o'clock the next morning when or 7 o'clock, and everybody starts getting those kids out the door to the buses, and everybody swings by to drop off mail before they leave or pick up mail or whatever the case may be, they're going to be on those sidewalks again. Are they shoveled? Are they clear? They should be under your 12-hour. What if they don't meet their 12-hour window? Are you responsible? It's a complete analysis of what did you arrange for? What could you have arranged for? Did you cheap out to save money? at the risk knowing that you are going to have slippery spots. I mean, you have to take every situation and look at every piece of the facts and analyze it to, is that reasonable, right? And that goes in front of a jury, and the jury argues about it, and they come back and they go, yes, no, it was, it wasn't. It's not this black and white, yes, you're always going to be fine, no, you're not, never going to be fine. It's always going to depend on the circumstance. It's going to depend on what you could have done, what you did do, and why you did it. And, do general people have a responsibility to be safe? Because this is Colorado, and we all know that the sidewalks are going to be slippery. It's snowing. Yeah, we all know that. And so there's some obligation on individuals themselves to make sure that we've all done the right thing and paid attention and was, took proper precaution. But if you know a particular area is always super slippery, you have some duty there too, right? So it's a case-by-case analysis. So 3-story condo HOA, water stains on the ceiling unit. After various checks, a hole is cut in the ceiling to try and determine the source. It appears the water is coming from an outside vent. It's being addressed. Who's responsible for fixing the ceiling? I don't know. I'd have to look at the documents. Who owns the ceiling? Who owns the roof? Who owns the outside vent? How many times did they call in to say it was leaking? How many times has it been leaking? All kinds of questions. So kind of favorite answer, it depends. That's one of those things that, as you can't come to the right answer until you can see the governing documents. What if a builder has not completed a project? So there's these things in law called attractive nuisances. And so a pool is an attractive nuisance. Meaning it is a place where people can get hurt, and it's very attractive to children, and it's attractive to people. And so it's an attractive nuisance. And oftentimes an incomplete building is what's called an attractive nuisance. And so if you have a builder who has that going on, I would send that builder a demand that he properly fence it off, because it is an attractive nuisance and you don't want anybody being injured. If you won't listen, then have your lawyer send him a letter demanding that he fence it off so that no children go in there and get injured, because that would be considered an attractive nuisance. But understand, remember, owners owe different obligations to different types of people. So when someone goes into his property and is trespassing and gets hurt, it's a different area of liability to someone else who might be invited on there and gets hurt. So, he has a vendor come on his property and get hurt versus somebody who trespasses to get hurt. If you have a contract to remove snow after 2 inches fall, are you responsible if only 1/2 to 2 inches fall? So, okay, so that comes into your association is pinching pennies. We're not going to pay to shovel the sidewalks if less than 2 inches fall. And that may be a dollars and cents to save the community, but you're placing risk out there. That's what boards are doing. They're doing a risk analysis. What is our risk? How likely is it somebody's going to slip in less than 2 inches of snow? It's a risk you take. Is that a reasonable action to ignore the snow because it's less than 2 inches? Maybe, maybe not. You might have a jury go, less than 2 inches is more likely to be more slippery than more than 2 inches. So that's actually when it's most dangerous to walk down the sidewalk. And so you created a more dangerous situation. No perfect answer there. I can't tell you that, what a jury would do, but if somebody slips and falls, again, that analysis, did you do what a reasonable person would do? If the HOA has roads to maintain, both regular maintenance and snow plowing, and the documents say drive at your own risk, is that enough to protect you? No, because if you if you own them such that you have to maintain them and you don't do so in a safe manner, the fact that you told your owners they're driving at their own risk isn't enough because you had a duty and you didn't maintain to your duty. What if a property builder does not finish concrete repairs? Sorry, Mary, I don't have enough information to answer that question. I don't really know. What do you mean? Did they cause a dangerous circumstance? Did they create a hazard? Is it dirt? I don't understand. And we're out of time, guys. It is 1 o'clock. Hopefully this gives you a better idea of how to look at something when somebody says, hey, something happened. Are we liable? A lot of times your answer is probably going to be, I don't know, it depends. That's what the lawyer kept saying. It depends. Because negligence is, again, an evaluation of what a reasonable person does. So everything is a case-by-case evaluation with a lot of facts, okay? So you're going to have to look through all your facts, look through all your information, and see if you can walk through the circumstance. And sometimes it means you're going to have to call a lawyer and say, here's what I got. What should we do, and what's our best protection at this point? I hope that helps everybody. And I have one more question. What if the association members will not approve the budget increase to account for the snow removal costs? That doesn't protect you. Unfortunately, one of the things, and it's a really bad analysis, but it's one of the things you can always look at. Surfside board members said that they've been trying to get raises and money from their owners and residents for years to do repairs. And when it collapsed and they were sued, insurance paid out every dime that they could pay, because whether or not the people bothered to pay the increase or not, HOA was liable for a lot of deaths. And so the fact that your owners are not budging and not helping your budget doesn't change the liability of the association. If the association is responsible to maintain, they're responsible to maintain. They have to find a way to get that budget money. Thanks, everybody. We're done. Have a good one.